revenue service excise tax, also known as the Cadillac tax, which will be on high-cost employer-sponsored coverage. Our presenter today is Sam Ennis. Mr. Ennis is an associate at the Sonosky Chambers Law Firm in San Diego, in the Sonosky San Diego office. Assisting us today with this webinar is Brian Howard, and Brian is also with NCAI and will be our webinar administrator. This webinar is brought to you through the National Indian Outreach and Education Initiative, also known as NIHO, a partnership between NCAI, NIHB, and the Indian Health Service. This webinar is for informational purposes only, and I will be reading a disclaimer to you shortly. Tribalhealthcare.org is on Facebook and Twitter, so please friend or follow us. At the end of the webinar, you will have the opportunity to ask questions. Let me go ahead and start by reading the webinar, or reading the disclaimer. So this training is for informational purposes only and is not intended as tax or legal advice. Please talk with your attorney or tax professional for specific questions related to your tribe or tribal entity as an employer. In addition, this training material is an introduction to the IRS excise tax on high-cost employer-sponsored coverage. It does not cover all of the IRS proposals in Notices 2015-16 and 2015-52 concerning the excise tax. So with that, what I'd like to do is turn it over to Brian so he can explain how our webinar system works. Brian?
Great, thanks, Laura. So I'm just going to go over a little bit of the functionality of our webinar system. Currently on the slide, you should be able to view on your desktop right now. You can see the control panels to the right, which I'll go over a little bit more in the next slide. But just for starters, the control panel is where most of the interaction will come from you relaying questions to our panelists today. As you can see, there's a function if you want to minimize the control panel, you can click on that orange arrow button. If you're having issues with your audio, we are using the telephone system for this webinar recording today. And make sure that if you're having any issues, just try and redial back in and make sure you enter your audio pin so that if you would like to ask a question over the phone later on in the presentation, we'll be able to unmute your line. And also, you can use the raise the hand option when we do get to part of the presentation where you may want to ask a question over the phone. Just click on the raise the hand option and that'll signal me to unmute your line. Another way you can also submit questions is through the questions box on the control panel. These will also be stored if in case we need to do any additional follow-up with you or get back to you regarding some other information. And with that, I'll go ahead and turn it over to Sam.
All right, thank you very much, Brian and Laura. And for those of you in attendance, thank you very much for taking some time from your day to be with us. Brian, we can go to the next slide. There we go. Okay. So today we're going to be talking about the IRS excise tax on high-cost employer-sponsored health coverage, which you might have heard about in the media as the Cadillac tax. And what we're going to do is talk about some of the background of the tax and its purposes, the amount of the tax and when it applies, who is responsible for calculating and paying the tax, what kind of benefits are taxable, what are the penalties for failure to abide by the tax rules, and then some of the ongoing concerns and questions that the tribal community has identified with regard to the Cadillac tax. So by way of background, on the Cadillac tax will not take effect until January 1st, 2018, at which point high-cost employer-sponsored health coverage, including coverage offered through group health insurance, self-insured plans, HSAs, FSAs, and other types of coverage, but the group health insurance and self-insured plans are the big one, will be subject to the excise tax if the plan value exceeds a certain amount, and we'll get to all that. the goals of the tax, according to Congress and the IRS and its implementation, are primarily to help pay for the implementation of the Patient Protection and Affordable Care Act, to rein in medical inflation by discouraging individuals from having such generous packages that they will go for health procedures or doctor visits that they don't really need but figure, well, I don't have to pay much for it, I might as well, etc. So it kind of is a two-pronged attack to raise some money for the ACA implementation and to try to discourage what Congress viewed as frivolous overuse of health benefits. Next. So the excise tax rules are currently set out. It was an ACA provision, currently in Section 4980I of the tax code, 26 U.S.C. 4980I. Currently, the IRS has not listed or issued any proposed regulations on the excise tax, which is not really that surprising given that it doesn't take effect for over 2 years. But currently, what the IRS did was issued notices 2015-16 in February and 2015-52 in July, in which they sought preliminary information from which they're going to gather, review, and then put together proposed regulations for public comment. In the two notices, the IRS talks about different ways of implementing the tax, covered services, what should or shouldn't be excluded, how to pay the tax in certain circumstances, etc., and really runs a very wide gamut of options. Tribes and tribal organizations have drafted responses to both notices. The February response to the February notice was due, I believe, in June or July, and response to the July notice was due on October 1st of 2015. But the tribal leadership met with with some of the IRS officials who were charged with implementing the tax earlier this month, and they informed us kind of off the record that the IRS would still consider comments from the tribal community received through the end of this month, through the end of October. And later on, after this webinar, in the coming days, NCAI will be providing to the participants a fact sheet on the excise tax, kind of a one-page overview of its most important provisions and some of the most important proposals, and also a template response to the 2015-52 notice. So once you have that, you and your tribe or tribal organization can review it, and if you have questions, feel free to contact me and to discuss. But if you feel that and this is a template version of the comments that have already been submitted by various tribal organizations and tribes, if it's something that you and your tribe agrees with, it can be placed on tribal letterhead and sent to the IRS through the end of this month, and will still be considered as part of the proposed rulemaking process. Next. So to begin with, let's talk about what is the excise tax and how is it calculated. Next. So the excise tax applies when the plan value of the health benefits, and we'll talk about what that means in a moment, exceeds certain statutory limits. Those statutory limits are a cost of $10,200 in the case of an employee with self-only coverage, and $27,500 in the case of an employee with any other coverage type other than self-only, whether it's family or self+1 or something like that. One thing to note is that the cost of paying the tax is not included in the plan value. So if your plan value is $15,000, it's over $10,200, you have to pay the tax. The amount of the tax is not then added on, tacked on to the plan value. It's considered a separate process. So the party that is liable for paying the tax, and once again, we'll talk about that in a moment, is responsible to pay 40% of the amount of each employee's total plan value that exceeds those statutory limits. So that's kind of the statutory grace amount. Under that, up to and including that, you're fine. Once you hit it or go over, you need to start paying on the excess amount. For example, if the value of an employee's self-only coverage is $15,000, the excess value would be $4,800. the difference between $15,000 and the $10,200 annual limitation, and then the tax penalty would be $1,920, 40% of that $4,800 excess value. Next. Please forgive our brief lag in PowerPoint changing after I say next. It's just a function of the system. So those were the statutory limits, the ones I just mentioned, but there are a couple of upward adjustments that will help raise that amount in certain circumstances. One thing that the IRS has noted is that those amounts will never go down. Nothing that they're going to do will lower the total, the statutory threshold, but there are certain things they're considering that might raise it. First is that the statute itself includes automatic upward adjustments of $1,650 for self-only and $3,450 for non-self-only for coverage provided to qualified retirees, which is defined as individuals age 55 and older who receive coverage by virtue of being retired but are not eligible for Medicare. And then by plans where the majority of beneficiaries are engaged in a high-risk profession, which in one of the notices the IRS said includes things like forestry work, longshoreman work, and other sorts of high-risk professions for which it's difficult to get affordable insurance for the employees just due to the nature of their work, as well as employees who are employed to repair or install electrical or telecommunications lines. Congress presumably heard from the telecom and electrical lobby and built an exemption, or I should say an upward adjustment in specifically for those lines of work. The IRS is also considering whether they have discretionary ability to include other upward adjustments for employee pools whose age and gender characteristics are different from those of the national workforce, which the IRS has proposed to figure out by examining federal employee health benefits plans offered by the federal government to get a representative slice of the demographics. And if it seems like, for whatever reason, you should have an upward adjustment because your employee pool has different age or gender demographics, the IRS is considering whether and how to do that. And then finally, there is an upward adjustment tied to national plan premium costs, basically medical inflation. But I'm not an expert on that specific area of the law, but from what I understand, that upward adjustment is drafted in such a way that it probably won't apply and probably won't provide much relief. So really it's the retiree, the profession-based, and then whatever the IRS plans to do with gender and age adjustment. Next. So as I mentioned, the IRS has the excise tax threshold is determined by examining plan value. Well, what constitutes plan value? So the IRS has proposed that in most cases, plan value will be the average cost of coverage for quote-unquote similarly situated employees who are actually enrolled in employer-offered coverage. So the IRS has proposed that there could be several different ways of determining who's similarly situated. For example, self versus non-self coverage within each type of plan offering. The IRS has proposed to potentially let the employer just do it themselves, say, hey, you come up with your own groupings for who's similarly situated. The IRS said, well, we could do it ourselves, current employee versus retirees and dependents, geographic location, et cetera. They said, we could codify specific types of cross-sections in the reg itself. And then they've also sought additional options proposed by commenters, including noting that the similarly situated standard itself doesn't necessarily have to be the one that they ultimately impose. And for example, they said, people have said you should tie it to federal employee health benefit plan costs, medical or health insurance inflation costs, et cetera. But they're currently still they're still thinking about the best way to implement that moving forward. Next, please. So for self-insured plans, as opposed to group health plans or other coverage, the IRS also proposed several different approaches specific to the specific methodologies for self-insured plans. The first one would be they call the actuarial basis method, where plan value is equal to a reasonable estimate of the actual cost of coverage for individuals determined to be similarly situated under whatever process ends up in there, and then calculated using sound and reasonable actuarial principles. Well, there are a lot of terms in there, obviously, that are very broad and could be read a number of different ways. And the question that the IRS is seeking comment on is, what is a reasonable estimate? What is a reasonable actuarial principle, et cetera? And that kind of underscores something that's important to understand at this point, is that there are certain statutory requirements that are obviously going to be governing law moving forward. But in a lot of the areas I'm talking about today, the IRS proposed very broad principles and said, please let us know what you think, or simply said, we don't know what to do, please inform us. So, well, the general gist of how the excise tax is going to work is set in certain ways. For example, the statutory threshold and the 40% value. There is going to be a lot of flexibility moving forward, which is one of the reasons why it's important that the tribal community examine this early and try to speak with one voice to the best extent that they can in order to ensure that within this broad spectrum, tribal interests are protected. So going back to the slide, we have the actuarial basis method, and the next one is the past cost method, which is basically looking back, seeing how much the cost of the plan actually was for a quote-unquote determination period, which the IRS defines, and then adjusting that based on the gross national product. And again, I won't bore you with the details on the formulas they've put forward for that, but those are kind of what the IRS is generally thinking concerning self-insured plans as opposed to group health plans. Next. So specifically, the excise tax is calculated for each employee on a monthly basis for each taxable year, which the IRS has proposed as being just a calendar year rather than a fiscal year. So each month, 1/12 of plan value is compared to 1/12 of the tax threshold to determine whether or not an employee's benefits cross the threshold for that month. At the end of the taxable year, you aggregate that for the amount of the employee's total excise tax for the year, and then you send it in to the IRS. Basically, this is very similar to the employer mandate calculation, which many people might be familiar with, where you kind of think of it in terms of an annual amount. You're liable for X amount per year, but it's actually calculated on a month-to-month basis in case you get a new health plan during the course of the year, or you drop coverage during the course of the year, or basically whether something like that happens, whether there's a change in coverage that could affect the excise tax liability. Liability is calculated monthly. It's not a situation where if you violate it 1 month, you're automatically liable for the entire year's worth. It's on a month-by-month basis. And it's one of the reasons that's important to note that it's month-by-month and it's employee-by-employee is that even though the cost of the plan itself is likely going to be determined by an average of the similarly situated employees, and we'll talk more about this in a second, but the IRS is considering whether other types of coverage should be taxable as well, stuff that is more specific to individuals that they use on an individual basis, meaning that if an individual used option X in 1 month, option X might count only towards that employee for that month. So while many employees may end up just being treated the same, there's definitely potential to have it calculated differently on an employee-by-employee basis, which is something that employers need to know. Next, please. So that's kind of the background of what the calculation is going to look like. So now you have to figure out, you have the calculation, who has to do the calculation, and then who has to pay for it. Next. So regardless of plan type, the employer itself is required to calculate the tax for each employee, and if they're liable, notify both the IRS as well as the individual who is liable for actually paying the tax, if that person's not the employer, which we'll talk about. So bottom line is that even if you as an employer are not personally responsible for paying the tax per se, you're still responsible for calculating the amount for which you're liable. Once you have determined the tax amount, the party liable for actually paying the tax differs based on your plan type. For a fully insured group health plan, the health insurance issuer, and not the employer, is responsible for making the payment. For coverage of HSAs or Archer MSAs, basically savings accounts that I'm not sure how prevalent those are in the tribal community, but in any event, for those types of plans, the employer is required to both calculate and pay. And then for any employer-sponsored coverage other than fully insured group health plans, HSAs, or Archer MSAs, which by and large means self-insured plans, the quote-unquote person who administers the plan benefits is required to make this payment, and we'll talk on that in a second. So if an employee has multiple coverage types, for whatever reason, they have an HSA through work as well as a group health plan, whatever the arrangement might be, if they have more than one liable payer, the payers basically just pay in proportion. So if, insurance X covered 75% of the benefits and insurance Y covered 25%, that's the amount of liability under the excise tax that would be attributed to both parties. As of now, the IRS has not released specific guidance concerning timing, the procedures for the notification for the payment, how you would report that as an employer. That is something they're kind of looking far to the future on that. They didn't really go in depth in either notice about the actual procedural aspects. They're more focused on the substance right now. So as of right now, it's not entirely sure how that's going to work, but we'll see what the IRS proposes moving forward. Next. So I mentioned a moment ago that for self-insured plans, the party liable for making the payment is the person who administers the plan benefits. When you're just kind of sitting there reading that, you would say, well, it's a self-insured plan. I'm an employer. I'm the person that administers the plan benefits. That's kind of my job, right? But in the second notice, in 2015-52, the IRS said that this was an ambiguous term that could mean any number of things. They could mean the person who administers the plan benefits could be the plan sponsor, which is the employer. It could be the administration of the person who's responsible for performing the day-to-day functions for administering plan benefits, which generally the IRS is referring to a third-party administrator there. Or, for example, it could be the person who has the ultimate authority or responsibility under the plan or arrangement with respect to the administration of the plan benefits, which really could be anyone. The IRS wasn't really clear as to whether this last standard, how it differs from the second standard, or whether that would be an institutional entity or actually an individual would be, at that entity would be specifically required to do so. And we'll talk about later in the presentation about some of the problems with this model and this proposal by the IRS that are also addressed in the template comment response that we'll be distributing later. But in terms of self-insured plans, it's really kind of up in the air right now as to who exactly is going to be the person actually making the payment. Next. So one thing I also want to mention about group health plans, as I said, plan issuers and not employers are responsible for paying the excise tax for fully insured group health plans as opposed to self-insured plans. So kind of in the media or in conversation with benefits administrators and tribal employers, you often hear people saying, well, they're responsible. If I have a group health plan and I don't self-insure, the group plan issuer is responsible for paying for it, not me. So wouldn't it make more sense just for me to go get a group health plan, and that way I'm not liable for the tax? It's their problem. They're the ones making the offering, etc. The problem with this is that the IRS seems to envision, and as we understand this is going to happen, group health plan issuers may be the ones, kind of administratively responsible for paying the excise tax, but they're then going to include that in the cost of coverage. They're going to find a way to underwrite that back in so that, well, the tribal employer might not necessarily be physically making the payments to the IRS, they're still going to be paying for the excise tax one way or another. So you have to, there are considerations as to whether the saving on the cost of having to actually, saving on the time of having to actually make the payments yourself is a worthwhile trade-off, because the group health plans will probably also include the administrative cost as the pass-through to the employer. But you have to recognize that even if you have a group health plan, it is almost certain that the plan issuer will find a way to make the employer pay for that excise tax amount, and having a group health plan is not a free pass, so to speak. Next. So one question that we have that we came about when we took a look at the statute and the 2 IRS notices is the question of whether tribal employers are even liable at all for the excise tax. Because as we mentioned, it's based on plan type, not provider type. And the statute doesn't actually mention tribes or tribal plans one way or another. What the statute does say, though, is it has a specific definition of what constitutes a covered governmental plan that is subject to the excise tax. And I'm going to violate the rule of never reading directly from a slide during a PowerPoint presentation, so bear with me. The definition for a covered governmental plan is applicable employer-sponsored coverage, shall include coverage under any group health plan established and maintained primarily for its civilian employees by the government of the United States, by the government of any state or political subdivision thereof, or by any agency or instrumentality of any such government. So they have, Congress put a specific definition of governmental plan into the statute and applied it to state and federal governments, and it doesn't say anything about tribes. And part of the template comment you'll see in a lot of the advocacy from the tribal community thus far has focused on getting the IRS to recognize this exemption and recognize that the lack of inclusion of tribal plans in that definition should be read as Congress specifically saying that they're not included, and that tribal plans offered by tribes, whether self-insured or group or whatever, shouldn't be covered by the excise tax and subject to the excise tax. Now, if this sounds familiar, it's probably because tribal advocates took a similar approach with regard to the employer mandate and argued that because the employer mandate did not include a definition of employer, didn't say, what the who was or wasn't an employer per se, that the fact that it didn't mention tribes meant that tribes should be exempt. And unfortunately, a federal court has rejected that approach, and the IRS has also said that they just disagree with that theory as well. The difference here is that with the employer mandate, there was no definition of employer that would or wouldn't include tribes. Here with the excise tax, there is a definition of governmental plan, and it doesn't include tribes. So that's a little bit stronger of a position as compared to the employer mandate, and it's something that the IRS is aware of. We've told them in our conversations with them personally, as well as in the comments submitted by tribal stakeholders, and we'll see moving forward what they end up doing one way or another with regard to tribal governments. Next. So even if the tribal government is not covered by, even if the tribal government is eventually covered by the excise tax rules, there's a second argument that could get tribes off the hook for at least certain individuals. So, I'm sorry, next slide, please. I'm sorry, previous slide. There we go. Skip the slide there. So anyway, I was saying the excise tax applies to excess benefits provided through quote-unquote applicable employer-sponsored coverage. And as defined, that means coverage that is excluded from an individual's income under Section 106 of the tax code, which is the section that says, certain types of health insurance are not considered income for the purposes of federal income taxation when provided by an employer. So health insurance provided by a tribe or tribal organization to an enrolled tribal member, a spouse, or a dependent is not exempt under Section 106, but is instead exempt under Section 139D of the tax code. And using similar logic as with regard to the tribes themselves, what we argue is that the definition of covered coverage says 106, tribal members getting insurance from a tribal employer are exempt under 139D. So even then, if the tribes have to pay the excise tax on behalf of non-tribal members, they shouldn't have to pay it on behalf of tribal members. And importantly for this definition, the exemption goes to individuals who are enrolled in an Indian tribe and not their Indian tribe. So for example, under our logic and our reasoning, somebody enrolled in Chickasaw could work for Navajo and they would still fall within this definition. It wouldn't be that they would have to specifically work for Chickasaw in order to take advantage of the benefits. All right, now we can go to the next slide. So, we've talked about the liability, what plan value means. So now I want to talk a little bit about the types of things that will be considered benefits to which the tax applies and which go into this overall calculation of liability. Next slide. So the statute itself includes a number of coverage types that are both specifically included from the tax and included in the tax, and excluded from the tax. And I'm not going to run down all of these here, but the big one obviously is actual health insurance, whether fully insured or self-insured for employees. And in this context, an employee includes an active employee, a retiree, an individual covered by COBRA, surviving spouses who are still on their deceased spouse's employer coverage, and other primary insureds. Next. And then there are certain types of benefits that are not subject to the tax explicitly in the statute. These include, a number of things here, but fully insured standalone dental and vision coverage. If you're getting that separately from your health coverage and it's fully insured, that's off the hook. Liability insurance, workers' comp, things of that nature that are really more about the employer than the employee, but other types of employee coverage as well, they're exempt from the tax and don't count towards the plan value. Next. So the IRS is currently considering, that the statute sets out certain things that are definitely in and definitely out, and the IRS is considering what type of other benefits maybe should or shouldn't be included in total plan value. Three of the things here of particular note are employee assistance program benefits. For those of you who might not be familiar, that generally is kind of counseling services for employees through a contracted entity for marital issues or drug or alcohol abuse, suicide. Things that are often behavioral health and life and lifestyle related are often provided through these EAP programs. Self-insured dental and vision coverage. Fully insured dental and vision is excluded by the statute. IRS wants to know what they should do about self-insured in dental and vision. And then the third one is kind of an interesting one. It's the on-site medical coverage that is provided by the employer at no cost to the employee that goes beyond first aid. If it's de minimis, if it's just like, having a fire extinguisher and a first aid kit in the office, that is excluded from the cost of coverage by the statute. But the IRS wants to know where they should maybe draw the line in terms of other types of on-site benefits, such as immunizations, antigen injections, flu shots and such, non-prescription painkillers, treatment of injuries caused by accidents at work. They want to know, a lot of employers may have these types of benefits, particularly if they're health programs or clinics or hospitals or whatever. They want to know if there's going to be, they want to know if there's a limit at which point above, a certain level of complexity or value, it should count towards coverage rather than being excluded. Next. Okay, so what happens if there is a breakdown and you don't pay your excise tax? Next. So if you fail to follow the excise tax rules, as we mentioned before, the employer itself is tasked with calculating the excise tax, doing the initial calculation, and then notifying IRS and the liable payer, whoever that might be. If an employer undercalculates the tax liability, everyone still has to pay the right amount, but the employer is then subject to a penalty equal to the amount of the underpayment. So if you have a $500 tax, you screw up the calculation and report $300, you still have to pay the extra $200 to make up the difference, and then you pay an extra $200 in a penalty. What's a little unclear here is that the penalty provisions in the statute only mention the employers who fail to calculate correctly. They don't say what happens if somebody fails to pay correctly, which presumably, I mean, it could be the exact same situation. It could be treated as a failure to pay, just a general failure to pay applicable income tax. I'm not entirely familiar with those rules, but that is something moving forward to keep an eye on, is the distinction between failure to calculate, which is in the statute, versus failure to pay. And there are a couple exceptions to this rule. So even if you're liable for the failure to calculate penalty, you can get off the hook if the employer demonstrates that it neither knew about the underpayment nor would have known had it exercised reasonable diligence. You know, for example, maybe somebody, if the IRS covers, flu shots and says those count, maybe somebody got a flu shot and it somehow wasn't reported, something like that. Underpayment was due to a reasonable cause and was corrected within 30 days. Say, for example, your HR person who's in charge of this, right before the calculation time, he or she quits or is fired, and you kind of scramble to get it in on time. And then when the dust settles, you realize you made a mistake. That type of thing should be an exemption. And then finally, you'll be exempt if the IRS determines that the penalty amount would be excessive or otherwise unfair in light of extenuating circumstances. And that obviously seems more like a facts and circumstances test, just based on, depending on what happened, if you're going to get hit with something that doesn't look like you really deserve in terms of your culpability, the IRS has the right to waive it. Next. So now I would like to talk about some of the ongoing concerns of particular note. And I mean, as Laura mentioned during the disclaimer, the two excise tax notices from the IRS go into excruciating detail about various ways to implement this. And we kind of touched on the more general overview, but there are some specific concerns that we have just from the analysis that we've done of their rules. Next. So I mentioned before, we talked about how self-insured plans, the person who's actually liable for paying a self-insured plan excise tax could be the employer, or it could be the third-party administrator, the TPA, or somebody else. In the second notice, 2015-52, the IRS proposed a fairly complicated system, or not so complicated, depending on how you think about it, for how the payment process might look if a third-party administrator and not the employer paid for the cost of a self-insured plan. And follow with me here. So first, the employer calculates its excise tax liability. No problem, that's in the statute. The employer then gives that information to the TPA. Still good. The TPA pays the excise tax. No problem. The TPA bills the employer for the tax cost. Okay, that seems like what's going to happen anyway. The employer will reimburse the TPA for the amount of the excise tax. Now, here's where things get a little weird. So the IRS has said that under their interpretation of the law, when the employer reimburses the TPA for the amount of the excise tax, that amount counts as taxable income for the TPA. So the TPA is following the statutory requirement, but say they pay a $10,000 excise tax and then get reimbursed $10,000 from the employer, that amount, that $10,000 is counted as taxable income, which will raise the TPA's income tax rate. The IRS has then said that what will have to happen is the TPA will calculate the amount of its excess income tax as a result from this reimbursement and then bill that to the employer as well. So not only is that, this kind of unnecessarily making third-party administrators involved in this process going to raise the cost of employer coverage and or raise the cost of the excise tax for the employer. But the IRS has also then said that they believe that the cost of this tax payment will go towards the plan value of the employer. So you're confused yet? So what they're saying is, if your plan, the plan value is $15,000, there's that $1,900 penalty we mentioned after you do the calculation. The TPA pays $1,900. They then charge you, $300 for the tax amount. Now your plan value isn't $15,000, it's $15,300, which means you're liable for more tax, both excise and then ultimately tax payment to the third-party administrator. So the IRS's proposal here creates this self-perpetuating cycle where you have to keep paying more in tax, which in turn drives up your cost of coverage, which in turn makes you pay more tax. And one of the comments that we made in the template that you'll be receiving is that the IRS should not resort to the IRS should not employ this kind of methodology. And we can go to the next slide as well. The IRS should not employ this kind of methodology, which will lead to ever-rising costs for the employer. In addition, we think that it's impermissible for a couple of other ways. First is that it results in the functional excise tax of the employer being above the statutory 40%. If you pay your excise tax and then get hit with another bill from the TPA, now you're paying 50% or 55%. And the statute says 40%, and we don't think this is permissible. And then also, there are a number of administrative difficulties due to a lack of coordination, contractual issues. How do you know what the employer or what the TPA's tax rate is? How do you indemnify one another, et cetera, et cetera? So one of the key comments that the tribal community has made so far on this process is that this kind of cyclical increasing payment is both bad policy and may violate the law. Next. So another issue we have is the scope of benefits that are included in plan value. In particular, two that I mentioned, the EAP, employee assistance, EAPs, and then on-site health facilities. So EAP programs, and again, I admit I'm not as familiar as I should be with how widespread this is among tribal employers, but EAP benefits target issues that disproportionately affect the tribal community, like substance abuse, domestic violence, suicide, things like that, and provide a very valuable resource towards bettering employee health, bettering relationships, bettering lives, and ultimately lowering healthcare costs because they help address issues on the ground before they spiral into something that leads to more costly medical conditions or acts of violence, et cetera. We think that, and have commented that including EAP benefits within the scope of cost of coverage will discourage employers from offering that coverage and could have a negative effect on the health and well-being of their tribal members, and or their employees, excuse me, which could then lead to higher healthcare costs, which is not what anybody wants here. And then the second one was some tribal health programs that operate facilities, they offer their employees certain medical benefits at the tribal facility, which allow them to just kind of keep the workplace happy and keep on, and allow everyone to take advantage of the fact that they're working at a medical facility and ultimately better the health of the workforce. And again, this is something that if the IRS included in the tax could be a problem moving forward and discourage this type of activity. Next. The third issue is the tension between the employer mandate and the excise tax. So the ACA employer mandate, which I've mentioned on the call so far, requires large employers to either offer coverage to a certain percentage of their employees and dependents or else pay a tax penalty. And traditionally, this is proven to be a problem in Indian country because traditionally many tribal employers did not offer employee coverage because either it was too expensive or because a large percentage of their employees were tribal members who just used tribal health programs or IHS facilities or were on Medicaid or something like that. And many tribes are now trying to get medical insurance for their employees for the first time, specifically to to comply with the employer mandate. But what they're finding, and I know this is particularly true in Alaska, but I suspect and have heard that it is similar elsewhere, is that the plans that are offered through group health insurance or the cost of self-insurance, because of the fact that tribes are often located in remote areas, or because of the fact that there tends to be high morbidity and higher health care costs among American Indians and Alaska Natives, who are often the employees, the cost of providing any coverage at all is higher than the excise tax limit or close to the excise tax limit, and it's become a real problem trying to find affordable coverage. So on the one hand, you have the employer mandate saying you have to go and get everybody covered, and on the other hand, and the employer mandate says when you do so, it has to provide minimum essential value. There's a certain set level of benefits that must be in a benefits package to satisfy the employer mandate. The tribes are going out there and getting this type of insurance to satisfy the mandate, only to find that, lo and behold, it violates the excise tax. So there's a tension here where the employer mandate says get coverage, and the excise tax says, but not too much coverage. And this is kind of a needle that's very difficult to thread for a lot of individuals and a lot of tribes, simply through market forces and through no fault of their own. And this is something that has been commented on both in the context of the employer mandate and the IRS excise tax as another policy consideration as to why tribes should be exempt from both. But thus far, we've been unsuccessful with the employer mandate, although there are other options being considered. And then the excise tax now we're going to have to see. Next. So that is all that I have prepared for today. I will leave you with one more reminder that, as I mentioned, there's going to be a fact sheet and a template comment being distributed, and I really highly encourage you to read the template comment, and if you agree to submit it on behalf of your tribe to the IRS by the end of the month or your tribal health program, or even if you disagree or don't think you have the resources to do so, keep an eye on the excise tax, because there are a lot, this has the potential to be very costly for tribal employers, and there are certainly a lot of areas of ambiguity left. So whether you comment now or whether you wait for a proposed rule, we really urge you to stay engaged with this issue and not to kind of let it go by the wayside, because as we found out with the employer mandate, that looks to have some fairly devastating financial effects for tribes, and there's concern that this excise tax could end up being kind of the next generation of that kind of financial hit, assuming that the ultimate final rule doesn't consider for tribes in some form or fashion. I know that the excise tax has been kind of a frequent subject of criticism with people when punditry or politicians talk about the benefits of, or the problems with the Affordable Care Act. And if you read the comments to the two IRS notices from various stakeholders, such as the business community, insurance providers, tribal health programs, there is a pretty unanimous voice out there that the excise tax should be repealed, and even if not repealed, that the IRS's two notices have some pretty substantial problems in terms of what they put out thus far, including some of the things that I've spoke about today. So, like I said, keep an eye out and take a look at the materials as you get them. And for now, I will turn it back to Brian and Laura for, I guess we have some time left for questions and answers. Thank you very much.
That's correct, Sam, and thank you so much for this important presentation. I do have one question so far, and Brian might have others. I'm going to go ahead and read it to you. Sure. The question is, we have a self-insured plan that covers multiple entities, i.e. employers. Who is considered the employer for purposes of calculating the tax? And then there's a second part. I'll let you answer this first one.
Great. That is an excellent question. Thank you for asking that. So when you have the IRS, the statute itself incorporates what are called the IRS employer aggregation rules in terms of figuring out who the actual employer is in these situations. And what the aggregation rules do is, and this is something that came up in the employer mandate as well, the aggregation rules are really geared towards corporations and business entities to discuss, if you have if a corporation has these subsidiaries, is each one considered for the employer mandate purpose? Is each one considered a separate employer? Are they all amalgamated together under the umbrella of, the biggest one or the biggest corporation, et cetera? They're incredibly complicated, and I won't go into the details now, but those rules are incorporated when determining who the actual employer is under the excise tax rules. And as I mentioned, the government, the excise or the aggregation rules really are geared towards business entities. And the IRS has specifically declined to promulgate rules discussing how governments and tribal governments fit within this framework. For example, is the tribal, the tribal council or the tribal government, is everything go through them? Is the tribal government one entity and the tribal health program another employer, and the tribal hotel another employer, the casino another employer? The IRS has said the tribe should take a good faith standard when figuring out whether or not to aggregate their business entities or whether or not to leave them independent. And that would presumably apply here. So that's a good question with an unfortunately unsatisfactory and complicated answer. That's something that we're going to have to keep an eye on in terms of the actual proposed rule.
Great. Thank you, Sam. And let me read the second part of the question. Sure. Also, it appears that the tax is based on benefits actually received, not the monthly premium paid for the plan. True or not?
That so yeah, it's in terms of benefits received and not what the employee itself pays. It's total. It applies regardless of who is paying what. It's the total value, and that is one of the things that the IRS is seeking comment on, and part of their evaluation for how to calculate plan value is the types of things that should be included, or basically what I went through in the presentation. But as of now, it is the total plan value. Yes.
Great. Great. Thank you so much. Hold on. I think there's another question coming in. Hold on. Brian, can you check to see if there are other questions while I'm checking on this one question I'm getting via email?
Yeah. So we did have one question. What about self-insured standalone dental and vision? For example, a tribe has medical plans through the FEHB, but maintains a self-insured dental vision plan that is completely separate.
So, the fully insured, as I mentioned, is covered by the statute, and it does. The fully insured health and vision are or dental and vision, are excluded. The IRS is currently seeking comment on whether or not they should also exclude self-insured dental and vision. And in the notice, the IRS says that it probably will exclude those benefits. As of now, it plans on doing so. We said that they should. In our comments, we supported that. But in terms of self-insured dental and vision, the jury is still out for now. We're waiting to see what the IRS says.
Okay, great. There's no other questions. There was a question just asking for your email, but we could share that in an email that we'll be sending with the copy of the presentation and webinar recording.
Yes, as long as I have folks on the line, if you want a copy of my email, it is S as in Sam, E-N-N-I-S, S-Ennis, one word, at Sonosky, S-O-N-O-S-K-Y, S-D as in San Diego.com. So that's S-Ennis, one word, at Sonosky, S-D, one word.com. And you'll be getting that later.
All right, we got one more question.
Okay.
Is the total plan value an average of all insured or calculated as an individual?
It is, it's going, as proposed by the IRS, the constant caveat of as currently proposed, it is once you determine the similarly situated individuals, however that ends up being determined, it is the average plan cost for all such individuals. So, if you broke it down as people in your Texas office versus people in your North Dakota office, it would be an average of everyone in Texas that's how you would figure out the plan value for those similarly situated employees.
Sam,
Okay, great. We got
questions.
Oh yeah,
I have one question that came via email.
Okay.
Okay. So the question is, what action steps are being taken? Let's say, what action steps is anyone aware of to strongly advocate against the interpretation that the tax applies?
That's another great question. So for both, the point was made in responses to both of the excise taxes, the excise tax notices. A template was prepared through the National Indian Health Board and was submitted advocating against the inclusion of tribes by, I know, the National Indian Health Board, the Alaska Native Health Board, groups of tribes and tribal organizations nationwide. I'm not sure if Tribal Self-Governance and NCAI did as well, but I know they've been included in those discussions. So there have been several comments submitted, and then also a meeting was held between some of the leadership from the Tribal Self-Governance Advisory Committee with various officials in the Internal Revenue Service in order to kind of talk about various employer-related issues in the ACA, at which point leadership from self-governance communicated directly to the IRS that not only have we submitted these comments, but we really wanted to reiterate and emphasize how important an exemption is for tribes on the ground. In terms of what you can do moving forward, there's kind of, always the general, if you are working in the community, just, keep your eye out for things like this, for news from the national organizations or from your tribe about proposed rules. In this case, we're going to have several bites at the apple because we've had the 2 notices, responses to both, and again, you'll be able to respond yourself once you get a template of the comment response. And then eventually, there may be more notices. The IRS has not said, but if they do issue more notices, we will respond accordingly, and we'll have templates available. And then finally, eventually, the IRS is going to issue a proposed rule, which will set out more definitively what its thinking is. And if we get an exemption in the proposed rule, that's fantastic. If not, that would be another avenue to both submit comments and try to consult and engage in government-to-government negotiation with the IRS pursuant to, for example, the Tribal Technical Advisory Group, Tribal Self-Governance, and other avenues.
Great. Thank you so much, Sam. I did want to mention that NCAI and Tribal Self-Governance did submit comments supporting the interpretation that this provision doesn't apply to tribal governments. So I just wanted to add that. We have come to the end of the webinar, and I wanted to thank everyone for participating today. We will make sure to circulate the PowerPoint, the fact sheet, and the comment template by tomorrow. So you will have all of those materials by tomorrow at the latest. And we, again, encourage everyone to submit comments. I don't know, Sam, if there's anything else you want to add in closing, but we're at the end of the webinar time.
No, once again, thank you very much for spending part of your day with me via teleconference from here in sunny San Diego. And please do not hesitate to email me, give me a call. You can Google my name and I come up on the firm's website. Feel free to contact me if you have any further questions or comments or would like, with either in general or with the materials you'll be getting tomorrow. Thank you all very much.
Yes, thank you, Sam. Thank you, Brian.
All right, thank you.